So we're going to pick up with a topic which is, I think, particularly geeky even by legal standards, which is limitation, and it's I think on the face of it, the law of limitation is relatively short, and it's found in a single act of Parliament, the Limitation Act 1980, and it appears on its face relatively simple. It's just full of bear traps for the unwary. And the reason why we obviously care about it is because you might have the best case in the world, but unfortunately, if it's time barred, that's it. There's a complete defense to that claim. So it's a case of a relatively binary position. If you miss the deadline, you miss the deadline, and that's the end of your claim. This is an area of law that's sufficiently challenging in its application that it's one that one of my friends works on the insurance side in professional negligence is the area which you find the greatest number of claims against solicitors. So even experienced practitioners get the law in this area wrong. Given the degree of complexity in this area of law, we've just touched on what we think are the most important issues for practitioners to consider. We don't go into them in detail. And to catch off of Guy and Ed, I think if there's a single takeaway from this session, it's to assume that time is running for limitation purposes until you've absolutely persuaded yourself that it isn't. In terms of the pitfalls we're going to touch on, Adam's going to tell you about missing contractual limitation periods. I'm then going to tell you about failing to identify the time at which a cause of action accrues, which is a fairly common mistake. Adam's then going to tell you about failing to identify where a claimant has sufficient knowledge to pursue a claim for the purposes of Section 14A of the Limitation Act, which extends time for claims in cases of negligence. And then I'll finish up by telling you about failing to identify the time at which a fraud or concealment could, or with reasonable diligence, would have been identified for the purposes of Section 32(1) of the Limitation Act. As you'll see from the slides, there are a few additional slides which we've included which relate to sort of procedural issues, so failure to serve particulars within the 4-month period in which a claim form's valid, things like that. They're primarily issues which, if you're instructing external solicitors, are issues for them rather than yourselves. But in the event that you're pursuing a claim without external support, it's worth bearing those points in mind. So I'll start off and just give you an overview of the primary limitation periods, and this is all back to school, but basically in contract, tort, and breach of statutory duty, the basic position is that you've got 6 years to pursue your claim. In claims in contract, that's 6 years from the date of breach, unless you're claiming under a deed, in which case that period is extended to 12 years. In tort, you have 6 years from the date on which the cause of action accrued, and we'll go into some detail on when exactly that is. In negligence, you can extend that period by 3 years for latent damage, and we'll talk about that. Adam's going to cover that. And there's a 15-year long stop. In terms of other genuses of claims, so claims for personal injury and defamation, there are different limitation periods, but we're not going to touch on those for the purposes of this talk. And then finally, there's the extension which I referred to before in cases of fraud, concealment, or mistake, which restarts the primary limitation period running at the point at which that fraud, concealment, or mistake could or should have been identified. In terms of parties' ability to contract out of those limitation periods, generally the court is fairly comfortable with that, subject to certain limitations, which Adam's going to touch on shortly. And at the end of our limitation period, making sure that we're issuing a claim in time, what do we need to do? Essentially, the position is that you need to, for the purposes of English law, have pursued your claim. That is contacting the court to attempt to issue the claim, as opposed to necessarily getting a sealed copy of that claim. A point to bear in mind, which is covered in the procedural section at the end, is that if your claim's governed by foreign law, that might not necessarily be sufficient. So Case in point is a case about a Greek law governed claim, and Greek limitation law provides that one needs to both issue and serve the claim within the relevant limitation period. And so unfortunately the claimant in that case lost their claim by virtue of missing that point. Final 2 points to note from this slide: the court's not going to take limitation issues of its own initiative. It's for a defendant to pursue a limitation claim, a limitation defense rather, and in the event that they do so, it's going to be a complete defense, subject to the claimant being able to prove on the balance of probabilities that the limitation defense shouldn't apply. And obviously, if they are unsuccessful in doing that, the claim's dismissed. So over to Adam for the next bit.
Thank you, Ben. So one trap for claimants is shortened limitation periods, which could be lurking somewhere in the contract, because it is possible for the parties to contract out of the limitation regime or to agree different limitation periods, as long as clear wording, really clear wording is used. That's because those clauses are going to be subject to the reasonableness test in the Unfair Contract Terms Act, or UCTA. And enforceability under the reasonableness test in UCTA involves looking at the overall facts and circumstances to decide on whether these clauses are reasonable. Where the parties are sophisticated commercial entities of equal bargaining strength, and the courts are much more likely to uphold even quite draconian clauses. Contrast that, though, with the position of an individual or an individual consumer, where under the Consumer Rights Act, the court will be less willing to uphold clauses which appear in any way to be unfair. So I've got a couple of contrasting examples. The first one up there on the slide, the case of Granville. The Court of Appeal there was considering a 9-month limitation period, which appeared in standard trading conditions. And the court considered the reasonableness of that period under UCTA. And the passage up there on the slide, when they decided that the 9-month period was reasonable, you'll see the Court of Appeal saying that it's less enthusiastic about UCTA's intrusion into contracts between commercial parties of equal bargaining strength. But contrast the outcome in that case with the next case on the slide of Mitchell Design. There, the court was considering a clause which required the claim to be made within 28 days of the appearance of any alleged defect. So not surprisingly, that short time period didn't pass the UCTA reasonableness test. And the Court of Appeal in that case had particular regard to the Schedule 2 guidelines in UCTA, which include whether compliance with that condition would be practicable. And the court's concern was that this 28-day period, the case involved cracking and design defects, just wasn't sufficient to enable necessarily noticing of these defects or indeed having time to act upon it. So that clause failed based on this sort of practicable type test. So from a defendant's perspective, these clauses can be really quite handy, giving you defenses at trial, strikeout opportunities, or even just sort of leverage and settlement negotiations. Up there on the slide is a typical clause which reduces the primary 6-year limitation period, this one reducing it from 6 years down to 4 years. Now, as Ben said, I'm going to cover section 14A and the additional 3-year extension which claimants can get in certain circumstances shortly. The clause up there on the slide reduces the 3-year period down to 2 years. What I'd say about these clauses is they're both very, I would describe as client friendly. I see Andy, my colleague, smiling. I did have a hand in drafting them, and we were very conscious of trying to appear reasonable. Contrast that with the 9 months in Granville or the 28 days in Mitchell. Yeah, you can see that these are quite a lot more client friendly, which gives you more opportunity in terms of enforcement. But as the Granville case shows us, where you have sophisticated commercial parties of equal bargaining strength, then the court may be more willing to uphold even quite draconian short time periods. Equally, the more draconian you make these clauses, the more sort of pushback you can expect from your customers. So there's obviously a balance to be struck between risk and commerciality. Back to Ben.
Thanks, Adam. So in terms of claims in contract, as I touched on earlier, the limitation period runs from the date of breach. On its face, that seems a relatively straightforward proposition. But the bear trap that people fall into on this issue is failing to pursue a claim within the period in which services were performed, as opposed to when non-payment of an invoice was made. And there's a sequence of cases which deal with that over the next couple of slides. I'm not going to go into them in detail given timing, but they're for you to consider in more detail. In terms of claims in tort, the accrual of the cause of action depends on which tort we're dealing with, and most of the cases in this area relate to negligence. And in negligence, the cause of action accrues on the date on which damage is suffered, and that's the date on which an ascertainable loss has been suffered. A contingent liability isn't sufficient to start time running, and that there's the leading case. There is a case called Sefton, which Adam's going to talk about in a bit more detail shortly. But the general point to note from a bear trap perspective is the court is very, very reluctant to categorise losses as contingencies. Ultimately, you should be aware that damage may well have occurred before you've suffered any financial loss. And a sort of paradigm example of that situation is a solicitor negligently advises a client in the context of a contract. They enter into that contract. They've suffered a loss the moment they enter into that contract by virtue, or are likely to have, by virtue of the fact that they've received a bundle of rights which is worth less to them than they anticipated by virtue of the fact of that negligence. So don't assume that just because you haven't suffered any financial loss, you haven't suffered any loss for the purposes of limitation. And there's a variety of examples of that over the next couple of slides. Again, Adam's going to go into this point in more detail in section 14A, so I'll just pass on to him so that he can cover them in that context.
Thanks, Ben. Firstly, just a quick comment on contingent losses, because as many of you know, I sit on the defence side of claims against professionals, and I see claimants often trying to categorise tax losses in particular as merely contingent. And there's a string of really quite helpful, if you're on the defence side, tax planning cases which support the loss accruing when the scheme was entered into. If the scheme doesn't work, as Ben just said, this reduced bundle of rights is acquired at that point, not later, when HMRC ultimately assesses the liability. And the helpful cases, Pegasus, Integral Memory, Halsall, and most recently, McLean and Thornhill. And some of these cases come up in my next section now on section 14A, because this is a topic of real interest also to professionals and defendants. That's when claimants are trying to argue that time shouldn't start to run until they have the requisite knowledge based on section 14A. So in negligence actions, not claims and contract, negligence actions, section 14A provides an additional 3 years from the starting date of the claimant's requisite knowledge. Now, this 3 years might not actually start to run until many years after the primary limitation period, which is one of the reasons why we have the 15-year backstop in the Limitation Act. So this gives rise to a lot of issues around what actual knowledge is required to start the 3-year clock ticking. Now, apologies, it's a very long section, but what I've just put up on the slide is subsection 6 to 9, which are particularly pertinent to this question of knowledge. Important to bear in mind that the focus is very much on knowledge of the facts. Facts about both the damage, but also the attributability of that damage to a defendant. Subsection 6A, you'll see underlined the focus on the facts about the material facts about the damage. And then subsection 7 applies a relatively low threshold of that damage being known by the claimant to be sufficiently serious to justify proceedings on the assumption that those proceedings aren't defended. So that is quite a low threshold. And in subsection 8, again, the focus is very much on the facts, this time on the facts which are relevant to the attributability to a particular defendant. Now, the common trap for claimants is the belief that they can defer issue of their claim form until they know they've definitely suffered a quantifiable loss and that this was caused by a negligent defendant. And those of you with good eyesight will see subsection 9 at the bottom, which actually says that knowledge of negligence is irrelevant when you're considering the requisite knowledge under 14A. And there's been a run of authorities which makes it clear that something significantly less than definitive knowledge will actually suffice, starting with the House of Lords decision in Hayward and Fawcett's, which is the leading decision in this area. A number of passages up there on the slide, including just embarking on the preliminaries, a broad knowledge of the essence, or just a real possibility that the damage was attributable to negligence, or even enough to just justify setting about investigating the possibility that the advice was defective. And this broad knowledge of the factual essence of the damage and the potential claim against the defendant is well illustrated in the cases that followed, starting with Cole and Scion, which involves some poor innocent professional footballers who'd been lured into some tax planning schemes which didn't work. And enough there, you can see from the slide, was knowledge in broad terms of the complaint, the defendant's responsibility, and a real possibility of causation. The next case of McLean and Thornhill, this was a claim against tax counsel arising out of some failed film schemes. And enough there being knowledge that if the scheme did not attract the tax benefits, then the claimant would be worse off. And the key question posited in that case, would the facts have caused a reasonable person in the position of the claimants to take independent advice? And finally, on this slide, Whitcomb, was there some reason to consider that the advice may have been wrong? Which brings us really to the what I describe as the high watermark in tax cases. That's the integral memory decision, where the court found the requisite knowledge, even though the claimant there was just considering consulting with his tax lawyers and tax counsel. So something well short of definitive knowledge. So sorry for laboring through the cases. There are many more in this area, but I think they are helpful in showing that all that's really required is what's been described as the factual essence of the damage, and that a defendant was in some way responsible. Now, in tax planning cases, attributability is usually quite obvious if a tax planning professional has either recommended or implemented the scheme. But what I find in these cases when I look at them is that often there are much earlier signs of the loss and who was responsible than what the claimant is asserting in terms of the 3-year clock. Now, there are many different nuances to these cases. They're very fact-specific, incredibly technical, gives rise to a lot of contested applications in court. I won't have time to go into them any further, but for those who are particularly interested in limitation, there might be some of you, I'll be happy to come around and talk to you again.
There's a lot of significant overlaps with the extension of time under Section 14A and separate extension of time which is available under Section 32(1) of the Limitation Act. And so a lot of the principles that Adam identified are very common between the two. So Section 32 of the Limitation Act provides that the limitation period doesn't run, i.e. the primary limitation period doesn't run until the claimant has discovered a fraud, concealment or mistake, or could with reasonable diligence have discovered one. And to give you an example of the kinds of claims that we see in this space, I've recently been advising on a securities fraud case. And in that case, a company had made a number of misleading statements to market. And the question is, when would a reasonable claimant, having undertaken reasonable diligence, have identified the possibility of pursuing a claim? The leading authority in terms of what that test looks like is a case called Paragon Finance, and you've got the quote from Lord Justice Millett on the screen. I think from a practical perspective, the key point to note really is that the standard that's been applied by the court in terms of what is reasonable diligence is somewhat up in the air at the moment. There are quite conflicting authorities, and so I think what we need to do is pursue at the least favoured nation version of that test, which is from a case called ECU, in which it was held that essentially reasonable diligence can extend to have issuing proceedings or pursuing a pre-action disclosure application. So it's essentially the court has to apply a two-stage test. Stage one is whether there is anything to put you on notice of inquiry, should you be inquiring, and that's a question about essentially a fact-specific question as to what a reasonable party in your position, an objective question. The second stage is whether what a reasonably diligent investigation would reveal, and as I said, what a reasonably diligent investigation looks like on the facts is from ECU, potentially embarking on the issuance of a pre-action disclosure application in order to make out a claim in fraud. So notwithstanding that you've got these, there's essentially a tension between your professional obligations not to plead fraud without good grounds, and separately this possibility of the expiration of the limitation period. And I know, being friends with one of the counsel who was on for the claimant in ECU, that they don't particularly like that decision and think it was wrongly decided. But as at the moment, it stands as good law as a first instance decision. The next few slides give a flavour of various different cases in which this test's been applied. Allianz is worth talking about. That's a claim under Section 90A of FUSMA, in which various different claimants have pursued claims against Allianz arising out of misstatements which it made to market, which they say caused them loss in acquiring or holding securities. And in essence, in that case, Miles J basically provided his view on this issue, and he essentially said what's reasonable for one claimant, i.e. someone that holds shares through a tracker fund, may well be very different to what's reasonable for someone that holds a very significant direct position in the relevant defendant. So there's a differing standard applied, both in terms of how much information you would consume in order to ensure that you were on notice of relevant issues, and also once you were on notice of those issues, what steps you would reasonably take. There are obviously financial constraints and things like that to be considered, which I thought was a fairly fair approach to the issue. As I said, ECU was a slightly different case, and actually in this instance, the limitation defence wasn't actually determined summarily, and actually that Allianz was an example of an attempt to strike out a claim early, failing on the basis that it was a proper question for evidence at trial. ECU was determined at trial, and in essence, the claimant's limitation defence succeeded. It's a case all to do with HSBC basically trading on the basis of knowledge of how ECU was going to trade because it was its broker, and essentially there were hints in the evidence that ECU was aware that there was a problem, and they'd actually complained to HSBC saying, we don't really know what's going on, but it seems like the market keeps moving against us every time we go to place a trade. That's a bit weird. And essentially Mulder's view was that they had sufficient knowledge from around the time at which they were making those complaints to set them off on a train of inquiry. And had they engaged in a reasonably diligent investigation by virtue of being on that notice, they would have pursued a claim in or around that period, rather than deferring doing so until subsequently they found out by virtue of some regulatory investigations in the US that HSBC had been engaged in this misconduct. As I said, counsel who were involved in, at least for the claimant side, think that was wrongly decided, but it remains good law for the moment. So unless and until that changes, we have to proceed on the basis that the court might take quite an extreme approach to what reasonable diligence looks like. I won't labour the points on the next couple of slides because I think this is probably an area where you guys might have some interesting questions for us, and maybe there's more value in us taking those points, because you can look at the slides later to your heart's content.